I don't know.
Now you don't know if it's on or off. Welcome to technical difficulties.
Oh, man, it started.
All right, come on back. We'll have to edit
I'm just going
it.
to keep it started.
Yep. You ready?
Yep. Hello, ladies and gentlemen. Welcome to another episode of Andrew and Andrew on Texas Criminal Defense. My name is Andrew Harrod, and the one having an existential crisis to my left is Mr. Andrew Decker.
And it now actually matters that I'm to your left because
Yes, first time we are recording side by side.
first time listener, last caller.
last time listener probably. If any of you follow us on Instagram or maybe even some of the other socials,
The Twitter, the Facebook.
yeah, you may have noticed that we have bought some new technology for the show.
So Mr. Harrod thinks we need to grow our audience.
Much to probably both of our chagrins, we have new tech.
And so now we have video, we're doing drops and hints and polls. We did a poll.
Which we basically ignored
Well, no, we didn't.
for half of our audience.
For half, right. They voted even.
It was dead even.
So 20 people voted. We know we have more listeners than that, but 20 of you voted.
We don't have that many. I don't have that. I don't have as many followers on my Instagram as the show has listeners.
I don't either. Yeah, that's
So
true.
We do. I think need to get the show an Instagram account.
And I'm in charge of social media, and you're looking at me like I'm in charge of this now.
We'll talk about it.
Okay.
Well, we may talk about it.
All right. So gun laws. We're going to talk about in the future. I think we actually have a guest coming soon. I got an email back from a potential guest.
Excited about that.
Excited
Really
about
excited
that. We always like having a guest.
Yes.
But it means today we're going to talk about jury selection. And I know that has Mr. Harrod just giddy with anticipation.
I love jury selection. We have spoken briefly on jury selection.
Right. I think early on we had jury, you're being deselected.
Right.
It was more about like
The mechanics.
the mechanics of jury selection. Some of you who follow us on the social medias know that I've taught now a couple of times on jury selection for TCDLA and for continuing education purposes.
Yeah, which is a great honor. Also,
It's a huge honor.
So
Huge.
congrats to you.
So big.
And they don't just pick any old riffraff, so you should feel good about that. Another thing that our video watchers will notice is my dog Winston
the dog
is very interested in you sitting right next to me. That rarely happens.
Well, normally I used to sit across the desk,
Yeah,
and now we're doing this.
Yeah, he's
He's never been. I don't think he's been this close to me and been this calm ever in his life.
right. Yeah, this will be fun.
Yeah.
Okay, so jury selection. Some people call it like the most important part of a trial. What do you think about that?
I think it's very important. Yes.
You like closing. I mean, that's
Well, I like all of it where I'm the center of attention. Let's be clear.
well. Jury selection, certainly you can put on a show. You can make it memorable for the potential venire members.
Right.
But it's also that and opening statement. Really, the only time you get to talk last.
Right. That is correct. That is correct. So what I really want to talk about though, so one of the things that I know is the best lessons I learned are where I made a mistake and went back and went, how do I do it better?
Yes.
So recently, you've been in my jury selections, haven't you?
Absolutely, yeah. Handful.
And one of our other guests has said, Andrew, you may have the best jury selection I've seen from a defense attorney ever.
Unnamed guest and I have not heard this at all.
Well, you hold her in high esteem. So
I will say your jury selection is effective.
Right. So I tend to do pretty well. But recently I was doing a jury selection. Hi, Winston. He's licking my hand, and it's
weird.
It's weird. He
Never
never pays attention to it. And during jury selection, two things happened. Well, one, we were running late. Actually, so maybe three things. We were running late because the state rambled. for lack of a better term.
Yeah.
And then I knew, without anybody saying anything, I needed to try to cut mine a little short because it was going to be late in the day, and a jury, if anything we know, people stop listening after about 3:30 because they're tired.
Yes.
Because what is that for you, Mr. Herrick?
Oh, that's nap time.
Nap time. Right. So I knew I was gonna be a little bit limited just in practicality, even if nobody actually held me to a clock.
Well, you read the room. That's important.
Right. I'm somewhat socially aware.
Yeah.
Right.
Yes, that I will say. Awkward and aware. Yeah.
Oh. Thank you very much. So I read the room. I realized I was going to have to be moving a little quicker than I normally would, and I was just like, okay, fine. I've really prepared this for less time than I was allotted, based on how long the state went. But during my explanation of beyond a reasonable doubt, as it's getting late in the day, Sue Sponte, the judge, says, Mr. Decker, we've already covered the aspects of the law and beyond reasonable doubt.
Gee, thanks, Judge.
Right. Yeah. So there's a problem there. And I, wanting to not get in a fight at the moment, said, Judge, I just need a few more minutes to make sure I get my point across. Well, anytime, and you and I have said, sometimes you object because it's objectionable, and you can throw the other side off their game. So like in the middle of trial, you object to a question not because the information is not going to come in, but just simply you make them go, what? Yeah. Where am I?
Yeah, they lose that flow.
You lose the flow. So I lost my flow, and then I never really got it back. I felt like I lost the room a little bit. Right?
Yeah.
So
I'm sorry, buddy.
It happens. It happens. I'll be okay.
One of your failings.
Oh, yeah. All right.
Harsh. That was too harsh.
That was pretty harsh. So part what I do is I spend a lot of time, and Mr. Herrick I think knows this. I spend a lot of time on the civil standard of clear and convincing evidence.
Yeah, same.
Right? Because beyond a reasonable doubt is what?
Not defined. Not
defined, and it's more or less than clear and convincing.
Highest burden in the land, way more than clear and convincing.
So also, I've told you, I on the fly is when things hit me the best.
Yeah, I like this analogy. I think you're about to talk to me about the analogy that you normally use on clear and convincing.
I might say that you have to come see me in person to get all my tricks.
Okay, all right.
Right.
Pay a fee. There's an entrance fee.
All right. It's so you have to go to some CLEs occasionally. I can't get everything. No, what I was going to say was the last time I was in jury trial doing a jury selection, the same trial, I realized the chart starts with at the bottom probable cause, right?
Yeah.
Which is very simple, clear and articulable facts or belief that a crime is being committed.
Yeah, right.
Right?
Agreed.
And that's enough to get an arrest, a warrant, or in a felony, what's needed next? Indictment. So on the chart, what comes above indictment? What comes above what's middle?
What do you mean what's middle?
So what's 50-50?
Oh, preponderance.
Right. Where does the indictment phase sit in comparison?
Below that.
Right.
Yeah. At probable cause.
Probable cause is less than 50-50.
Well, a lot less.
Well, it's at least less.
It certainly is.
Right?
Yeah.
I pointed that out, and the judge coughed. Right? Because
we'll talk off show about who this was. You've told me some stories, but I didn't hear about this part.
So he just kind of coughs, and I was like, I wonder if I did something wrong. I think the judge was kind of commenting on, don't tell the jury that the indictment, and I actually said, held up the indictment. I said, this is less. This wouldn't get you money
In a civil suit.
In a civil suit.
Right.
Right? Because again, you want to push that indictment as far down the chain as you can, because a lot of us, how many of us watch the news and someone says, well, Donald Trump is in trial right now. Donald Trump, former president, was indicted on electioneering by paying off, doctoring his books to pay off Stormy Daniels for sleeping together, right?
Yeah.
He was indicted today, and if you're not an attorney, what's your feeling? It's like,
oh, dang.
Dude, man, he's going down.
Right. Well, I mean, yes, and whatever you believe politically, certainly.
Right, I'm just using that as we've all heard.
That day, yeah, we're like, oh my gosh, it's insane.
Yes. So when you realize that's not even 50-50.
Right.
Technically.
Yes.
Huh. Right? It kind of hit me like a bolt of lightning. I said it, and the judge kind of coughed. Well, I went back. I think the charge stands. I've never had it objected to. I plan on using that in the future.
Right. Yeah. I mean, no, I think...
The civil standard says...
I think that's a solid argument.
Right. So I'm going to actually refer to a couple of cases, because once I had that, that kind of, we've already talked about the law, I was like, I'm not going to have to teach on jury selection after I've kind of lost my jury selection to a judge. Well, now I have my file, like I have a folder in my Dropbox with cases labeled jury selection.
Good.
Right? And there are things but if you go over them ahead of time, so that, again, sometimes to be the smartest person in the room, right? Often, one of the things I've noticed is prosecutors will say that beyond a reasonable doubt is just common sense. Have you ever heard that, Mr. Aaron?
I don't know. Specifically, probably.
You used it as a prosecutor, didn't you?
Oh, yeah.
On a DWI, you're like, it's just common sense.
I focus on, well, it's not beyond all doubt.
Right. Not 100%.
Yeah.
Right.
I don't know if I've ever heard it's just common sense. That to me would I would probably object to that.
I didn't object because I knew I was going to use that against them.
I rarely listen when the prosecutors are talking.
You rarely listen when anyone's talking.
That's a joke, everybody out there.
My part wasn't.
I am an active listener.
So, where was I? We were talking about...
I wasn't listening.
I totally lost my train of thought. Thank you.
No, beyond a reasonable doubt.
Beyond a reasonable doubt, right?
Yeah, being common sense.
Right, common sense. Well, one, it's not common sense. It's higher than that. But to use, again, make yourself look like the smartest person in the room. So when the state tries to lower it to something like, well, it's common sense, and then later you push that clear and convincing evidence as high as you possibly can, you can say, so ladies and gentlemen, and it may be you save it to closing, they called it common sense. We've talked about what clear and convincing evidence is and beyond a reasonable doubt. Why would they do that? Because they want to make this easy.
Yep.
They want to make this light and fluffy instead of holding their own feet to the fire of what beyond a reasonable doubt really is. So sometimes you want to leave that common sense out there. Hold it against them.
Right.
Right? Or they didn't show the